tense showdown erupted at a recent Senate hearing as lawmakers and legal experts clashed over how the Supreme Court's latest rulings impact civil rights and voting maps. The debate pitted a frustrated senator searching for bottom-line answers against a defiant civil rights attorney who accused the High Court of getting the law completely wrong. What we are seeing here is a classic Washington standoff. On one side, you have a politician trying to distill complex constitutional law into a simple, common-sense soundbite for the public. On the other side, you have a civil rights lawyer refusing to simplify the issue because in the legal world, the details are where the actual rights are won or lost. The tension began when the senator attempted to connect two major Supreme Court decisions, Students for Fair Admissions, the high-profile affirmative action college admissions case, and Callais, the recent congressional redistricting case. To establish his point, the senator turned to Mr. Phillip Grime, the attorney who successfully argued the Callais case before the Supreme Court. The senator summarized his own view plainly. The Supreme Court's overarching message to both colleges and state legislatures is simply to get out of the business of using race entirely. Mr. Grime agreed with the summary, noting that the court is treating these as political questions and drawing a hard line against using race as a factor. The senator scores an early point here by getting the very lawyer who won the case, Mr. Grime, to agree with his basic premise. For a brief moment, it looks like the committee has a clear, unified takeaway. Race is officially off the table. However, that consensus quickly evaporated when the senator tried to get Mr. Ernest Cox, a civil rights attorney on the panel, to agree. Instead of a simple yes or no, Mr. Cox launched into a dense legal history, pointing back to an earlier case called Robinson and arguing that Louisiana was actually required to redraw its maps to protect black voters under Section 2 of the Voting Rights Act. The senator cut him off, visibly annoyed, complaining that Mr. Cox was speaking like a lawyer and demanding to know what Mr. Grime had gotten right or wrong. This is where the wheels come off the bipartisan tone. The senator's frustration is palpable. He doesn't want a law school lecture, he wants a straight answer. But from Mr. Cox's perspective, giving a simple yes or no would be abandoning a decades-long legal strategy that protects minority voting power. He's intentionally resisting the senator's trap. When the third panelist, Mr. Ron Chamberlain, chimed in to defend Mr. Grime, joking that he wasn't about to tell the guy who literally won the Supreme Court case that he didn't understand it, the senator tried a more philosophical approach. He asked Mr. Cox point-blank if race should ever be used to help or harm an individual in America. While Mr. Grime and Mr. Chamberlain gave an absolute, definitive no, Mr. Cox refused to give a simple answer. He argued that if a racial violation of the law occurs, the remedy must be race-conscious to fix the damage. This is the philosophical core of the entire debate. The senator, Mr. Grime, and Mr. Chamberlain are arguing for a colorblind constitution, the idea that the law shouldn't see race at all. Mr. Cox is arguing for a race-conscious framework, meaning you can't fix past racial discrimination by suddenly pretending race doesn't exist. It's an irreconcilable difference. No disrespect, Mr. Cox, the senator concluded as his time ran out. You're not answering any of my questions. I know you're disappointed in the decision. I'm not disappointed, Mr. Cox fired back. I'm outraged. In a parting shot, Mr. Cox urged Congress to use its power as a co-equal branch.
I heard the Supreme Court say, look, colleges, we're not going to get into the admissions business. That's your business. We're just telling you, you can't use race as a factor to admit anybody. Is that your understanding of the case?
Basically, yes. And they did a whole 14th Amendment.
Don't try to muddy the water to make it look deep, guys. I know you're all smart. I'm just trying to get to the bottom line. Am I wrong or right?
You're right.
Okay. Now, the way I read Callais is the Supreme Court is saying, look, first of all, these are political questions. And we're not going to tell the states how to draw congressional districts. We don't want to be in that business. That's a political question. We're just saying you can't use race as a factor. Is that what they did in Callais, or am I misunderstanding it?
That's basically it. You can use it to remedy, past discrimination that you've proven. But that wasn't the case in the Callais case. The other side didn't prove it.
Well, but this, once again, you're muddying that water, man. Did the court, or did it not, say that you can't use race to draw a congressional district?
In most cases, you can't unless the state, the person defending the map, shows that they had to use it because there was a showing of immediately past intentional discrimination, that they had to use race to unwind.
Okay.
Yeah.
Tell me whether he got it right, Mr. Cox.
Senator, quite frankly, the defense of the Callais case is such a tortured exercise. It's
Mr.
difficult.
Cox, I don't want to hear.
So I'm going to tell you what SFFA, how SFFA applies to Callais.
Did he get it right, or
he did not get it right? Okay. So under the application to discuss Callais, you have to really discuss what happened in the case that created the district that was challenged in Callais. That was Robinson.
All right.
The court required the state of Louisiana to redraw its plans pursuant to its findings of a Section 2 violation.
Look, I don't
That's
want to
what
have a fight.
justified the creation of the
plan. I don't
plan.
want to have a fight. Can you just tell me, and you're smart, and I don't want to make this more complicated than it is. Tell me what he got right or wrong.
I'm telling you, what he got wrong was ignoring...
No, you're speaking like a lawyer, okay? And I'm tired of... I've listened to you gentlemen, okay? Let's just get down to it. Mr. Chamberlain, tell me what Mr. Grime got right or wrong.
He got it all right. You think I'm really going to tell the guy who argued and won Callais that he didn't understand what he was arguing?
Okay.
Sorry, I'm totally respectful. But obviously, I think he's got a good handle on it.
I understand that, Mr. Cox. I don't mean to be rude, the importance of precedent and all that. But didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person, and that includes in drawing congressional districts?
In answering that question, I'm going to tell you that the Robinson Court, which gave rise to the district that was challenged in Callais, said that there was a violation of the Voting Rights Act, that it was required to draw a district or draw a redistricting plan that satisfied the Voting Rights Act, that allowed African Americans to elect candidates of choice.
You don't want to answer my question, do you, Mr. Cox?
I'm answering your question.
No, you're not.
Maybe an answer that you don't like and my colleagues don't.
No, you're not.
But I'm answering your question.
You're giving us another lecture, and this is not a common law class. Tell me in simple terms, is that not what the court said?
The court said a lot of things that were inaccurate. So that court said you can't use race at all in drawing plans. We disagree with that. But what the court really did was say that you can prove race you can prove there's intentional discrimination, which is in violation of this Congress's intent. It also sprinkled partisanship as a defense for any challenge to any challenge under Section 2.
All right, well, I'm about out of time. I can see, no disrespect, Mr. Cox, but you're not answering any of my questions. And I know you're disappointed in the decision. But let me put it another way. Do you think race should be used to help a person?
I don't understand that question. Race should be used to help a person?
Do you think race should be used to help a person?
I believe that if there is a racial violation of the law, that race discrimination, I believe a remedy that's race conscious can be required, yes.
Do you think race should be used to harm a person?
I don't really understand what that question means.
No, I didn't think you would. Mr. Chamberlain, do you think it's fair in America to use race to help a person at the expense of other races?
No.
Do you think it's fair in America to use race to hurt another person?
No.
How about you, Mr. Grime?
Absolutely not. Race should not be used to help or hurt an individual.
And no disrespect to Mr. Cox. He's very bright. I can see that. And I've been where you've been. You know, when you get in front of a court of appeal and you're losing, you want to kind of obfuscate. I get it. But that to me is what the court's saying here in all these cases. we're not going to try to run your business. Not in the college admissions, not in drawn districts. But you can't use race. Period. End of discussion. And I think that's what the Constitution says and what most Americans support. I know you're disappointed, Mr. Cox.
I'm not disappointed. I'm outraged.
But that's what the Constitution says.
Well, can I add one more thing that's
Sure.
not quite exactly addressing what you asked? I do think there's a role for a co-equal branch of government, Congress, to make its own determination regarding how it wants its laws enforced. And I would urge this Congress to reconsider Callais in that light.
Yeah, but you and I are both aware that the United States Supreme Court has full authority to pass on the constitutionality of a statute. Come on, you know that. I'm sorry, Mr. Chairman.
If Mobile versus Bolden is any example of what can and can't happen, this Congress can take a look at Callais and say, actually, you got it wrong. And you actually didn't interpret what we intended in 1982 correctly.
The problem with your argument is, I don't think race should be used to help a person because of his race. And I don't think race should be used to harm a person because of his or her race. And I think that's what most Americans believe. And if you don't believe the opposite, and you clearly do, this is America. You can believe what you want. But the Supreme Court is deciding these cases.
I hear you.
Saying race is off the table.
I hear you. And I believe as a civil rights lawyer that if you find a violation based on race, you need to craft a remedy that addresses that.